Welcome to the Ottawa Business Journal's live broadcast of Signed, Sealed, Updated, Revising Employment Agreements the Legal Way. I'm Michael Kern from the Ottawa Business Journal. Thanks for coming out today. These series of employment law webinars are doing fantastic. We see so many people registering in advance and turning up. It's really great to see. And of course, this is yet another in a series of virtual events produced with Emond Harnden LLP. It's fair to say we've amassed a full video library over the past few years. You can check that out at OBJ's YouTube channel to find them. And I should point out that all registered, that's the key point, registered viewers get a follow-up email with a replay link. So I know there's a lot of live viewers joining at the last second here during their lunch hour, but we do encourage you to register in advance. All right, let's get down to business. It's pretty inevitable these days in our ever-evolving work world, the terms of a contract governing an employment relationship may need to be revised from time to time. Sound easy? Well, you're best to proceed carefully. Properly updating an employment contract can be a challenge, and the legal and financial consequences of any misstep can be significant. Today, we're going to learn about several related aspects of this topic, the importance of fresh consideration to employees to ensure amended contracts and termination provisions are enforceable. We're going to talk about the steps to mitigate the risk of constructive dismissal claims when terms and conditions change, and why employers should regularly review and properly update employment contracts despite potential risks. Okay, let's meet our guest today. She is part of the legal team at Emond Harnden LLP. Founded in 1987, Emond Harnden is the largest group of lawyers specialized in labor and employment law in the National Capital Region and beyond. She is a return guest. Please welcome Negeen Yazdani. Hey, Negeen, how you doing?
Hi, Michael. Good, thank you. Thanks so much for having me on again today.
Yeah, I think this is, as we said in the intro, kind of something that happens inevitably, especially I find in this ever-evolving work world where people's contracts, their job descriptions, their titles, they need these adjustments. And sometimes entrepreneurs and business leaders out there could think, well, that's just simple. I just update a piece of paper and I send it to them and we're done. But that's not the case, right?
No,
right, Negeen?
yeah, you've got it exactly right, Michael. Unfortunately, it's not quite the case. And the employment agreement is such a pivotal document when it comes to the relationship between employee and employer. So very, very important to get it right and not kind of use the template that we've been using for the past 20 years, right? Making sure we're constantly looking at it and
for sure. And we're going to cover lots. In fact, we'll look at our agenda right now, Negeen. Topic number one is the importance of fresh consideration. Emphasis on the word fresh there. Topic number two, the risk of constructive dismissal if you don't handle this correctly. And topic number three, the importance of reviewing and updating agreements. Sometime around 12:25 p.m. for our live audience. We'll be taking your questions. So this is a really cool opportunity to speak directly with a legal expert. All right, let's jump in with both feet. Negeen, topic number one, the importance of fresh consideration. We'll bring up some slides to so some visual enhancements and take it away from there.
Excellent. So yeah, as we'll be chatting about in this first topic, you can have the best employment agreement out there, but it needs to be backed by fresh consideration. When we're talking about updating employment agreements, we'll want to make sure we have this key piece, which is called consideration. It's an element that is required by contract law. So I'm going to break it down a little bit for those who are not quite familiar with what that exactly means. So consideration in a nutshell, it means a transfer of value from one party to another, or it can be a detriment as well. So I'll get to a couple of examples momentarily, but I think employers will be quite pleased to hear that when courts are reviewing to make sure that there is this element of a transfer of value, they're not typically looking at the value of this transfer. So that means even a nominal amount of consideration is typically found to be, valid. What we don't want to do, though, Michael, is offer something that's illegal or fraudulent or, otherwise unconscionable. We also don't want that this transfer of value to be coming from someone who's not party to the contract. So we'll want to make sure we're steering clear of, those third parties who are, trying to offer value. We don't want it to be from a third party. Probably most importantly, though, Michael, we want to make sure that consideration is not something that's previously been provided. So what do I mean by this? Let's say, you have an employment agreement, you've entered into this arrangement with an employee, and maybe 9 months down the line, you've decided, I actually need to update this employment agreement. Something is not quite right. You can't say to that employee, in order to continue working for us or in consideration of, continuing to be employed or, continuing to receive the same benefits that you were entitled to under the first contract, here's this new contract. That is not what courts are looking for. They're looking for something new, something that you weren't already providing under the original contract. So that's sometimes what we see in the case law where, employers are offering employees to continue being employed or offering them benefits that they were actually already entitled to under the first agreement. That's where typically you see some challenges when it comes to wanting to enforce that second agreement, because there hasn't been fresh consideration. There hasn't been something new that the parties hadn't previously contemplated.
Okay. Let me ask you a quick, maybe two follow-up questions. So, fresh consideration. So, if I'm the employer, as you suggested, it shouldn't be if you want to continue working here, you must sign this document.
Exactly.
An employer's mindset almost needs to be like they're almost like a new employee. Like you need to adopt that mindset, so it's not deterministic or something like that. Is that it?
Yeah, you definitely don't want to be, telling employees, you're exactly right, Michael, to continue working here, you have to sign this new agreement. Instead, while there is no one size fits all approach, typically, you can offer consideration that takes the form of maybe a signing bonus or an increase to salary, maybe even additional vacation time or pay that was, more than what they were originally offered, or, other new benefits. So there's certainly no one size fits all approach, but those are the types of things you typically see in terms of what does consideration look like in practice.
Okay,
You don't want to offer something that's already been provided. That's the key there.
Yeah. New consideration and an enhancement is the word I'm thinking about. But I like what you said there. Could be here's some extra vacation, here's a bump in pay, here's some sort of other perk. And it always has to be better, of course, right? You can't be it has to be seen to be a value in the eyes of the employee.
Yeah, it has to be some value to the employee, or it could be a detriment to the employer. Or a combination of both, but it has to be something flowing between the parties that is different than the original agreement.
Okay, I like that, detriment to the employer. Okay, all right. Well, we're going to move on to topic number 2. Just a reminder for our live audience that you can ask your questions. So if something pops into your head, whether you're on LinkedIn or YouTube or some other platform, you can ask that question right now. We'll be filtering through them for 1225. And I think we're trying a new poll feature. So fingers crossed that works out. But Negeen will keep you focused on topic number 2, which is what happens if you don't manage this correctly, the risk of constructive dismissal.
Certainly. So this is one of the key risks we see in this area. When you're, looking at changing an employment agreement or changing a term to the contract, employers can be exposed to this risk. So what is constructive dismissal? This is when an employer, by a unilateral act, they have actually breached a term of the contract. And the case law supports that there's kind of two steps to this. The first one is, the employer has to have done something that breaches the agreement. And secondly, it has to be to an essential term of the contract. So, this, for example, this is usually when there is a reduction in the hours of work, or changing someone's location quite substantially of where they're performing their work, or removing managerial duties from them, for example. So these, as you can guess, are changes to quite essential terms of the contract. And so, there is a risk that employees may make a claim for constructive dismissal. Now, this is a highly fact-driven exercise. And so, I can't, in the absence of, specific facts, say that it's always going to result in a claim of constructive dismissal. But something to be mindful when we're making changes to the contract is, do we need this change to the contract? Is it to a fundamental term of the contract? And, you want to be very, very careful and, clear that you do have the consideration, and that you ask for the employee to clearly acknowledge their acceptance of the change. So just something to be mindful of in this area. And certainly, something to consider before we go ahead and make, fundamental changes to an employment agreement.
Let me ask you a quick follow-up on that one, Negeen. So let's say in topic number 1, we gave fresh consideration. So let's say I'm presenting someone with an updated contract. There's a salary increase. In that new contract, I wanted to change the reporting structure, or let's say remove some managerial duties. If I did step 1, can I get it, sorry for putting it this way, can I get away with step 2? Or I still could be in, and I see your highly driven fact exercise, so I'm sure there's lots of gray in this, but if I give fresh consideration, it's very clear advantage or benefit, and then I change something that's essential to the term of the contract, am I still on thin ice?
I mean, you've certainly mitigated the risk to a great extent. Okay. Now, I guess the risk is that an employee, they don't have to actually sign off on the new agreement. To effect a constructive dismissal claim, employees in effect have to resign and say, no, I don't have to accept this new contract because you're changing a fundamental term. So the risk does remain that they can make this case. Now, if you've offered fresh consideration and you do get them to clearly sign off, there's no duress, you've given them the opportunity to review the new agreement. These are all steps we can take to mitigate the risk that they're going to be successful in those claims.
That's the ideal situation. So I think what I heard you say is, taking that first step, offering fresh consideration, is the proper thing to do. It doesn't completely mitigate the fact that they're going to come back and say, what do you mean I'm no longer a manager? No, I'm not signing this. So I get it.
Yeah.
And there's always a degree of back and forth in contracts. And, when I think of employment law, I'm always thinking we're managing human relationships. So there's a really high degree of legal complexity and people complexity coming together.
Yeah.
Okay. Well, listen, we're going to go to topic number 3. The questions are already starting to go in. So I encourage you, if you hear Negeen say something and you're like really curious, ask that question. And I think we're testing that poll. So fingers crossed again. We'll be coming to people in about 10 minutes time. Topic number 3, Negeen, is the importance of reviewing and updating agreements. Let's take it from there.
Sure. So, I've, any good lawyer is going to advise you of the risks, before you proceed. And you may be thinking to yourself, well, why would I want to expose the employer to some of these risks? Why is it important that we're constantly reviewing employment agreements and updating them? So we've come up with these 3 different areas on the slide, and these are just, not the only benefits and not the only reasons, but in broad strokes, you're going to want to make sure that you're always staying on top of legislative changes. So what do we mean by that? As I'm sure most people are aware, the Employment Standards Act of Ontario governs minimum standards legislation when it comes to the employment relationship. And so this Employment Standards Act is constantly being amended with different minimum standards or new minimum standards, or entitlements that employers once had. We find out that those things have changed as a result of amendments. So we can draft an employment agreement that today is 100% compliant with employment standards legislation, but next year, in 5 years, 10 years, they may no longer be reflective of what's in place at that time. And so when you want to maybe enforce your agreement at the end of a relationship, you may find that because minimum standards have changed, you can't actually rely on what's in the contract anymore. So that's one example. And I can really give a concrete example. A couple of years ago, I believe in 2021, the Employment Standards Act was amended such that non-compete clauses were rendered mostly prohibited. There's a couple of exceptions when it comes to sale of business or executives, but in large part, what we've seen as a result of that amendment is that we can no longer put enforceable non-compete clauses in employment agreements. So just a quick example of why we always want to be making sure that we're reviewing the changes and making sure that our agreements are always in compliance with the current state of the law. So that's number one on the slide. I can take us to number two. So we've said remaining up to date with common law developments. So what do we mean by this? So, employment agreements are largely designed to limit exposure. This is one reason we have employment agreements, to limit exposure to employers in a couple of areas. So, termination, severance, confidentiality, intellectual property. And so let's hone in on termination. And what we're seeing in the common law, so this is when judges are opining and they're giving their interpretation of employment agreements, we're seeing that there's a constant evolution of their interpretations of termination clauses. So what do I mean by that? We can draft an employment agreement with a termination clause that, based on the state of the common law at that time, based on the decisions and the case law, it's in our legal opinion enforceable. However, what happens is that judges, cases make their way up through the court system, and judges are providing different interpretations on different language, or interpretations that they once held are no longer, in fact, the state of the law at that time. So this means that you always want to be making sure that your termination clauses, as an example, are always based on the case law at that time, and based on the interpretations that we know based at that time. So it's constantly being changed, it's constantly evolving, and things that were once the case may no longer be the case. So always making sure that we're up to date based on what we know in the common law. And then I can take us to number three, so reflecting changes in the business and employee relationship. So I think this one is hopefully quite self-evident, but you hire someone 20, 25 years ago in a certain position, and not only maybe does their role change, but also maybe the business evolves and the expectations are different, the entitlements are different, obligations are different, and so you want to make sure that, to the extent those things are changing and evolving, your employment agreement reflects what's actually in place, what's in practice. And this way, if it ever comes time where you have to enforce something in there, you've documented that there's a clear understanding and a clear agreement between the employee and the employer of what those obligations were and what entitlements are. So very, very important that we're constantly reflecting on what changes may be occurring in the workplace, and how we can update employment agreements to reflect those.
Yeah, it's been kind of an underlying theme throughout all of these virtual events, right? That things are always in a constant sense of flux as legal decisions are made. And I think that's what keeps employment law really interesting, I presume, on your side. And We keep getting a good turnout. So all these entrepreneurs, business owners, and HR experts are turning up to hear the latest. But it is important, as you said. You touched on a couple minefield big issues: the non-compete and the termination clause. I think some of your colleagues have talked about that. Those are always really some of the contentious issues where we saw some changes, I think, in 2025, Negeen.
Yes, yeah. Termination clauses is where we see typically it's an area prone to, dispute or litigation. So you can imagine that at the end of a relationship, there may not, you want to make sure that there's a clear agreement on what entitlements exactly are. So it's one of those things that we have to get exactly right so that there's no room for ambiguity, and we're very clear on what we're providing our employees.
Okay. We're doing great on time, which is fantastic. We like the interactive component, and it's a real benefit for people that are registered and chiming in here. So before we go to these questions, Negeen and I were chatting, and I always want to flag that we're putting Negeen on the hot seat here, and legal questions aren't like math questions. They're it's not always 1 + 1 = 2. So we'll put some questions up here, and Negeen, if you can help, that's great. And if you prefer to follow up 1v1, we can facilitate that. So the first question from the Wild Bird Care Center. I like this. I love the little icon there. But anyway, the question is, for term employees that are returning in multiple summers, more than 6 months between the job or the job period, do you still need to include the previous year's terms, or can the agreement treat the employee as a new employee? So very relevant for this time of year where lots of businesses and organizations have summer students. Any thoughts on that, Negeen?
Yes, certainly. So this is one of those things where I'd have to see the contract, but I'm presuming that the original contract set specifically a start date and an end date for the term. So I know typically when we draft them, we say this is, for example, a 6-month term beginning on this date, ending on this date, and beyond that date, there's no more employment contemplated. If that's the case, there's a clear start, a clear end. And there's a significant break in service, like you've mentioned. Then all signs are pointing to the next time they may join on. It's kind of a separate arrangement. So you'd be looking at offering a new fixed term contract, and at that point, to the extent you want to change something, you can go ahead and you can change the arrangement. But yeah, in my mind, if that's how I'm reading the question correctly, it's they are.
And there's I like the assumption there too, and that's really smart. So I'm just going to explore that because it's interesting to me, and it might be very relevant and timely for people. So if we've got a summer student, let's say, coming in, and even if there's a chance after summer, maybe they're in university, they might do some really part-time work in the fall or winter. They're really the best advice on your side is no, have a start date, have a clear end date. And that's always that degree of clarity is a good starting point in that employment relationship.
Yeah, certainly when you're looking at a fixed term arrangement, the number one piece of advice we're giving is make sure you're really clear about what the term is. Now, to the extent there is kind of part-time work throughout the year, that may change our analysis if the relationship is continuing. But to the extent it's a clear start, clear end, then the thoughts I shared before would likely continue to apply. But again, this is one of those things where we really have to look at what was specifically contemplated in the first agreement, and what was the agreement between employer and employee, and then we go from there when we're looking at offering a term.
And a reminder again that anyone who registers officially for these live events gets a follow-up and Negeen's contact information. So if you really need a official legal advice on something, then best to follow up. Okay, I think we're going to go to Bonnie Shaw, who's got a couple of questions here. And let me try this one on. Our trigger in a tightly budgeted non-for-profit is an ever-changing allocation of duties. I've seen that before. Certainly, these small little nonprofits, it's all hands on deck, duties changing all the time. Nevertheless, so constructive dismissal shouldn't apply, but always, more so. Fresh consideration is key, but minimal. Maybe you can piece that together. Appreciating, Bonnie, that you're typing this on the go. So, but I think what they're saying is Bonnie works in an environment where there's a constantly shifting work duties. So if they need to actually update the employment agreement, do they need to give fresh consideration all the time? Pretty tricky.
Yeah, interesting one. So when we're looking at constructive dismissal, the risk is when you're quite fundamentally changing the job duties. So, for example, and this is maybe a more drastic example, but you're hired into job X. Throughout the relationship, we've turned your job into job Y. There's no obligation for employees to say, yes, I'm going to accept to continue to perform the duties of job Y because I was actually hired to perform job X. So that's quite different than, for example, the routine. Duties are constantly evolving, and that's fine. Now, in terms of the fresh consideration, to the extent the employment agreement is being changed, you're always going to best protect yourself as an employer when you offer this fresh consideration. And it doesn't have to be a huge amount, as I had previously explained. Even a nominal amount is going to can protect you against a claim that while the employee signed it, they may later argue, this isn't enforceable because you didn't offer me this piece of consideration that is a requirement under contract law. So it's a little technical, and sometimes it can feel like it's, I understand it can be frustrating and it feel like it's not so necessary, but it's always going to be one of the better protections employers can give themselves by offering.
Yeah. And let me try on, trying to be helpful here. If someone's job duties are shifting in this non-for-profit, but it's not an essential part of the contract, the agreement. So, you're not changing their seniority level. You're not changing, who they report to. So we don't need to update employment contracts for regular day duties or special duties. Hey, we've got a big conference coming up, Julie. So we're really going to need you to lean in and help us at the conference, that is. We don't need to go back, Negeen, and write another employment agreement, right? It's not an essential part of the contract.
Yeah, I think, Michael, you certainly made a lot of good points there. I don't think it's always necessary to update the employment agreement. You're right, Michael. When it's a typical, for example, we'd want to take a look because maybe the job employment agreement already says you'll be assigned these duties and any other duties that may be assigned from time to time. So that's typically language that we see, and in which case it would very likely fall under this kind of language. Now, if you're changing something that's very fundamental, it's and again, this is not legal advice, and this is being provided in the absence of an example. But
yeah.
I can say that unless it's a fundamental change to the job duties, you're not looking at always updating the employment agreement in these situations. But you'd want to take a look at what's contemplated in the agreement and whether you're comfortable that this kind of new job duty was something that was reasonably contemplated when the parties entered the agreement.
Yeah. And that probably speaks to having job duties that are, somewhat flexible. And I always remember that for first or second clause is something like, or duties related to the position, or that there should be a degree of flexibility written into the contract when it comes to, what people are doing on a day-to-day basis. I assume. Okay. Yeah. Listen, in the blink of an eye, we're suddenly at 12:30 here. So there are some more questions, but we'll be sharing Negeen's contact information. We're going to go to our key takeaways. So Negeen, a good opportunity for people just to reflect on some of the key points in
Sure.
today's broadcast. We'll bring those up on screen and have you walk through them.
Sure. So I hope that one of the key takeaways you've received as part of today's presentation is that we always want to be making sure we're reviewing our employment agreements. And so this means not only the template that we're using, is our template still a good template? Is it still in line with the legislation at that time, with the common law at that time? And then also, let's take a look at some of our employment agreements that are already in place. Do they accurately reflect, what's actually happening in the workplace? Is that still the arrangement that's in fact in place? So that's one of the more important key takeaways, to make sure that we're constantly looking at, can we improve these? Can these be made more clear, or more can the content be made in line with legislation and common law? The second point, just making sure you're aware that there is the risk of constructive dismissal, and there's always options to help mitigate, but it's one of those things that maybe before we take those steps to fundamentally change a contract, always recommended to seek some counsel and figure out what the options are, because there are some options. Third one, fresh consideration is critical. Again, this has to be a clear new benefit that's provided, to the extent we want to amend an employment agreement that's already in place and offer something different. And there's going to need to be that new transfer of value. Again, based on the examples I shared earlier, there is no one size fits all option, and there's different things we can look at providing there. Fourth one, outdated and poorly drafted agreements. They can increase the likelihood of these, disputes or unintended risks or obligations. So, while we can understand that it may take time and resources to make sure that your employment agreements are up to date and clear, but something to consider is you may be saving some time and headache down the line. So always recommended to take those steps at the outset, to make sure that you're thinking yourself maybe 5-10 years down the line. And then finally, again, you're making sure that you're reviewing these things proactively and regularly. You're making sure that you're hopefully limiting your exposure, and making sure that your rights and obligations are clearly defined, and increasing the chances of being able to rely on those agreements and enforce them to the extent that you need to at some point. So,
Good stuff.
certainly.
Yeah,
Thanks, Michael.
and listen, maybe one thing that the employers and entrepreneurs watching this should keep in mind, that it's best to invest a small amount of money to get a quick opinion on your legal and contract, rather than potentially incur thousands or tens of thousands of dollars in a constructive dismissal, right? You don't want to do that.
No, certainly. Yeah, we see it all the time, where you may not think you're exposing yourself to risk, but
Yeah.
unfortunately, based on some of the developments that have happened in the law, or based on changes to the legislation, you may be exposing yourself to risk. So always recommended to just get a quick review of your employment agreements, and not just once every 10 years, but quite regularly, to make sure that it's constantly the best that it can be based on what we know at that time.
Okay. And if you heed that advice, let's bring up Negeen's contact info. Here it comes. There you go. Phone number, email, find her online as well. So Negeen, listen, thank you very much. You did a great job. I think this is one of those topics that people are wrestling with on a regular basis. And I think what we might have achieved today is let people know that you simply can't just update what some people might think is a piece of paper and say, throw it on their desk and here's a new agreement. Have it back to me before the end of the hour. That's not workable. It's not
Definitely. Yeah.
not the best practice.
For sure. Yeah.
Okay. Well, you did a great job. Thanks, Negeen. We
Thank you,
appreciate
Michael.
your
so much.
involvement today, your expertise, and the support of Emond Harnden. So hope to see you really soon. Take care.
Yes, us as well. Thanks, Michael.
All right. That was great. Great job today by Negeen and our partners at Emond Harnden. Listen, a couple things before we sign off. Reminder to visit obj.ca website every day for the latest in local news. By the way, the website just got a completely fresh overhaul, new homepage, new article pages. We're seeing traffic up about 65% in the last 2 to 3 weeks. So it seems to be really working. One of the key components, by the way, is if you're on an article page, then we're doing what they call continuous scroll. So there's a bit of a refresh as you scroll down the page. Also recommend subscribe to OBJ Today. That's our weekday email newsletter. Thousands of Ottawa's business leaders, community leaders, political leaders subscribe to OBJ Today. I know you might be thinking, hey, what the heck do I need another email in my inbox for? But listen, this is super efficient. You can open it, scan it. Takes about 30 seconds. If you're interested, click on something. You can also follow us on social media. I think our LinkedIn is in the 44,000 range. So always on the increase in our YouTube audience. Please click the red subscribe button and the icon. Thank you for watching today. We hope to see you real soon. Take care, everyone. Bye-bye.